Hey guys, welcome back to the Adventure Channel. In today's video, we want to definitely keep everyone updated in terms of what's going on with Housing is Key. And today I have a few excerpts provided by the Tenant Workshop Program. This is through the state of California. They have these meetings weekly. I believe they have them on Tuesdays, which is Spanish. And then, of course, on Thursdays, it's all English primarily. And so they usually have a few guest speakers. And in this particular case, they were joined today by an attorney. And I decided to sit in on it and listen in on it through a Zoom conference. I don't think a lot of people really know about it. I think there was approximately maybe 40 to 50 people uh, on the high point that was online. But you had a number of questions that were answered, a number of questions that were addressed. A lot of people have legitimate questions, and it really just makes me fortunate, for at least myself and I, that my wife and I, we've been informing a lot of people here on our channel, because a lot of people just don't know what their rights are when it comes to rental properties dealing with landlords. And so a lot of questions that were addressed and maybe brought up within this live broadcast, which was a Zoom meeting, was, what is harassment? What are my rights as a tenant? And so definitely just want to share with you guys a few of the clips that were provided during the course of the meeting. Again, this was a public event. Nothing was private because obviously anybody could have logged in. This is an entirely public event. It was a pretty fun experience to really kind of join and sit in on it. I asked a few questions as well. A lot of things people weren't aware about, such as the $10,000 penalty for landlords. If you are being harassed by your landlord, it is a $10,000 penalty per offense. And I do believe that even if it's the property manager doing the harassment, then also the owner is subject to that as well. I do believe that is in the clause. I could be wrong, but you guys could double check that yourself. But a lot of questions are still up in the air. This is all new to a lot of individuals as far as what is the legal process as far as eviction. Now, as you guys know here on the channel, I did speak with Housing is Key, and the process is, which was answered or actually asked in the course of this interview or meeting, was what is the process? And the correct process is your landlords cannot evict you until you go through the Housing is Key program. So if they try to evict you, it goes to court, and then when you go to court, the judge will give you an opportunity, based upon circumstances, for you to sign up for Housing is Key. If you don't want to sign up, then pretty much you could be evicted, I think 3 days later, or pretty much right there on the spot. However, if you do sign up for Housing is Key, the eviction cannot go through until they actually qualify you for the program. So the eviction cannot go through until Housing is Key does their thing, which could then be another month or maybe another month and a half until you are pre-qualified. Now, if you are not pre-qualified during that time period, I do believe they will evict you at that time. You do only have like a few days. So again, everything right now is going through Housing is Key. Another thing is landlords just can't apply for Housing is Key even if a tenant doesn't want to. It is a bilateral initiation where both the tenant and the landlord has to do it. So you're both parties to that as well. Another thing I definitely want to mention is through the course of this conversation, I know some people think that Housing is Key ends in January. Remember, you guys have learned here on the channel, Housing is Key ends, or at least the next round, it started from October 1st to March 2022. A lot of landlords do not know that. A lot of landlords are not informing people. Now, there are additional papers as far as the new eviction moratorium and whatnot, as far as the new procedures. I'm not too well versed on that. But again, if you are qualified through Housing is Key, or if you signed up previously, there is a new link. You have to go back into your account in order to get qualified again and resubmit all of your documentation. So with all that being said, we'll go ahead and get into this meeting. This meeting was about 2 hours long. I've cut down some of it. It's definitely not all of it. So just wanted to give you guys a little taste of what you can experience with this particular call. I'm not going to provide the link or information as to when they have this weekly event. I'm not sure if I can give that out publicly or you have to request it yourself because I wasn't the one orchestrating any of this stuff. But hope you enjoy it and learn something from it. Take care.
Yeah, so there's a lot of resources for getting a letter, and it is true that sometimes a letter from an attorney or from an organization is more useful, and can get a response.
Yeah, because like we're not getting anything. Because I talked to an attorney, she's not a specialist in landlord tenants, but she said,
So don't tell me what another attorney told you, because I don't want you to.
oh no, I'm just mean she's not a specialist, but she told me to write it myself, and I put in the points, and like I said, still haven't got a response, and even like the lady from landlord tenant like called them and told them about like the notice was invalid because it was before the moratorium expired.
Right. So yes, I think speaking with IRA, speaking with the tenants union, and also submitting the form to State House Los Angeles are your best
Okay.
options right now.
Okay, thank you.
All right, I see Colette, you have your hand like physically raised, so I'll call on you.
Hi, how are you?
I'm
I just have a general question. If you are entitled to a relocation fee, does it depend on how much money you make?
if you are entitled to
A
relocation
relocation
fees,
fee?
yes, sometimes it does. If you are considered very low income, you might be entitled to more relocation fees versus somebody who might be a higher income, or if you have children or are disabled. Under the county ordinance, they factor that in for relocation.
But you are entitled to it even if you do have income. It doesn't matter how much it is, right?
I believe so. Yes, I believe
Okay.
that is true.
Okay.
You're not you're not entitled to the same amount. I don't think, but I think you cannot. You're still entitled to it.
Okay, because I live in Los Angeles and I have some like a case like some of the other people. This is I've been here 8 years and she's selling a house. She gave us a 30-day notice, but she hasn't offered a relocation fee.
Again, in the city of Los Angeles, not all houses, like single family homes, are under the rent stabilization ordinance, and if they're not under the rent stabilization ordinance, then there's no law requiring that the landlord give you relocation money. So not
Okay.
every tenant is entitled to relocation money in the city of LA.
Okay. So how will we find out if we are entitled to it? Maybe that's the
That's a
question.
great question. So you can find out whether your unit is protected under the rent stabilization ordinance by going to this really useful website called Zemus. I'm going to pull up the link and put it in the chat. You put in your address and you can it'll tell you if you're protected by the rent stabilization ordinance or the tenant protection act, which is a statewide act.
Oh, it went by so fast. I didn't get it.
Oh, it's just in the chat. So
Okay.
if you can access the chat, you but
Okay.
Zemas, ZIMAS is the website.
Okay. Thank you so much.
Of course.
Good
All
luck to
right.
everybody.
So I see somebody just with the name iPhone. I know that number has been or that person has had their hand up for a little while, so I wanted to see if there's somebody who has a question.
Hi, yes, I have a question.
Yes.
My question is though about a domestic violence restraining order that was provided to the landlord for my building, and I had provided a 14 days notice to move out due to safety reasons, and they are now requesting myself to violate my restraining order to contact the other party, and so that way they can receive like a 30 days notice because they don't want to have me just break the lease and the unit not be paid for, even though I provided the 2 weeks rent for the month of October.
That is definitely something I think that you need to discuss one-on-one with an attorney who specializes in um, the rights of people who are in domestic violence situations and under a law called the Violence Against Women Act, VAWA, because you are entitled to certain protections when that law kicks in. So I think I saw an email from you come in to me, and I can follow up with you on that about putting you in touch with the right person.
Right.
It gets very complicated when restraining.
Sure, please. Thank you.
Yeah, I'm so sorry about that. So, okay, because that technically, like, my 2 weeks is up now, but I know, well, at least I believe that they wouldn't like, they're supposed to give me back partial of the deposit, so that way I would be able to move out, right, if I gave them sufficient notice in regards to it.
I don't know enough about the situation or about your housing or your rental agreement to say that specifically.
Right. Okay. And okay, so if you've seen an email, would I receive any information in regards to that today, or do I still have to keep waiting? Because I mean, technically, what I provided to them was a note from myself, also with copies of the order itself 2 weeks ago. So that would mean that I would have to vacate the unit by this Sunday with whatever it is that I provided to them. But
so
who is
again,
it that I can speak to?
this is kind of going back to if your landlord gives you a note saying you have to be out by a certain date, or if you give your landlord a note saying you're going to be out by a certain date and you're not out by that date, that doesn't necessarily mean that does not at all mean that your landlord can just change the locks, kick you out, nothing. So your landlord might, because they specifically asked you not to follow the 14-day rule or the 14-day notice that you gave them, it likely won't make a big difference if you're still there on Sunday. It might get a big difference to them if you're still there on Sunday. It's just more your ability to preserve your own rights under the law and to be able to be in a situation that makes you safe. So I saw your email, and I will get back to you I will get back to you by the end of the day tomorrow. But know that if you're not out of the unit on Monday, it's not that you are going to be punished by the landlord in any way.
Right. Okay. All right. Thank you so much.
Yes, just a great summary in the chat. Landlord notice is not a court notice. Okay, there's a good question in the chat about the emergency rental assistance application that I'm going to address now because I think it's really important. But yes, you can request future rent relief through the ERAP, which is just what people are calling it. You can get up to 18 months total. So if you and if you request assistance for the future and you're unable to pay your full amount for the period that you're waiting on, yes, you can submit the notice of inability to pay because of COVID. You can submit the try to give your landlord 25% of the rent if you can afford it. And I don't know, I can't comment on whether or not the request for future rent payments affects the application or like your priority or anything. I don't think it does. I think they're encouraging people to request future money for future payments because they know that really not everybody has recovered from the economic impacts of COVID. So it's still ongoing. And I don't think they would have the option available to you if it was going to be something that would hurt your application. So I do encourage people to apply for the rental assistance. If you are financially struggling because of COVID, most people are. They've made a lot of money available. The state is being very slow to distribute these payments, but they are getting out to people, and it can really be a good lifeline. Okay, Matthew.
Sorry. Yes. Can you hear me okay?
Yeah, I can hear you.
Okay, very good. Oh, I'm sorry. Let me turn this off. So, Sarah, I am not quite in the position of most people here, but am calling because it's possible that I might be. My landlord rented this apartment to me a year ago, November, at what they said at the time was a discounted rate. I was getting some kind of a special. Now, I've been renting for over 40 years in my life, and I've never, the rent has always been the rent, and I've never been presented something that says, well, we're going to give you a discount now, but understand that this is your discount for this year, and then next year will be different. Now, I just got a letter at the beginning of this month, because my lease is up on November 1st or 2nd, thereabouts. And it says specifically, as you may know, your lease renewal is approaching. We are thrilled that you were able to take advantage of our exclusive special offer when you moved in during the month of November 2020, allowing you to save $163 each month on your rent. Now, that supposedly was off of whatever 163 plus $1,463 comes to, which I haven't done the math. But the thing I'm wondering now is that they're asking me to pay on my new 12-month lease $1,707 plus 103 for other monthly charges, which I assume might be the garage parking, because I pay 100 now. But just looking at that number now, I have talked with the Consumer Affairs about this, and they tell me, based on where I live here in Koreatown, that the maximum increase would be 8.6%. So it's a twofold question. One is that, can a landlord, my rent is $1,463. Can they base the new rent on some kind of discount, that 163, which I assume they added on to my $1,463 to come up with a new, in other words, this $1,707 is about, I calculated about 15% higher than what I'm paying now. So I'm confused. Are they allowed to do that? In other words, say that they made an offer, they gave you a special for the first year, and then somehow calculate the maximum percentage, which I understand is 8.6 for this property. Can they add it back in? In other words, claw back this discount, add it in, and calculate it from there to give me a new, is that?
So it does. So I can't speak to whatever math that
Okay.
your landlord is doing, but it sounds like
Right.
they're imposing too much of a rent increase under both what could be it's possible that you're protected by the Los Angeles Rent Stabilization Ordinance or the Tenant Protection Act, both of which limit the amount that your rent can be increased. So even with this, what if they're doing like weird math with whatever discount they gave you, the rent that you were paying for the last month is what, or last 12 months is what the rent was. Any weird discount they gave you, it doesn't matter. What they were charging a certain amount of rent, they cannot increase it more than whatever 10% or 8.6 or 3% if you're in a rent stabilized unit.
May I say, Sarah, I think you're absolutely right. And also, I believe that, well, if it is a 15% increase, it's a crime to increase the rent more than 10%. And what they're doing is a crime under the anti-gouging law, which is Penal Code Section 396. So you might want to look that up, and don't threaten them with a prosecution, but you can tell them that this increase is criminal.
Right. And the answer to what you should do next, knowing that they have increased your rent too much is, again, to reach out to the Los Angeles Housing Department, assuming that if you were in Koreatown, you were in the city of Los Angeles. They might have better information than the county would, because the county likely doesn't know too much about the city's laws. So they're probably the better resource for you.
Sure.
And they then also contact, because it is such a steep rent increase and because it's being entered into during a state of emergency, which COVID has been ongoing, it could be worth reaching out to the city attorney as well. But the housing department will, they can respond to this regardless.
And the city, Sarah, the city attorney, is that, could I just Google city attorney of LA? Is that?
Yep. And you will get their front page.
Okay. And go ahead. Yeah. Okay.
Yeah.
And just quickly, because in all fairness to the landlord, as far as I did speak with the Department of LA City Housing, LA City Housing, I believe it is, department. And they did say that if it's in the lease, that if they have spelled it out in the lease, which I have to admit, I can't recall, because to me, it sounded like when they were verbally telling me, I thought this is just some kind of a sales kind of, they just want me to rent this place out and they're giving me a special deal. So I kind of disregarded it and I just signed the lease. I looked at the numbers, but I don't recall. So she's saying that if they spelled it out in the lease that they were giving me a special, that it is possible there's a base rent that I would have, that increase could be based on. You know what I mean?
Would still gather that the increase is too much, because the decrease, the discount they were giving you was less than $200, and it sounds like at a bare minimum the increase that they're charging is more than double than what they can charge.
Just so you know, to help you, the increase is $244 from $1,463 to $1,707, just to mention that. So yeah, that's way above
the anti-gouging law says that the 10% is measured from the amount the tenant actually paid, not what it says in the lease.
Yeah.
That's what I thought. Right. That's what I've been saying too. Okay. And so you would say, Sarah, and I'm sorry, the gentleman, I didn't quite remember his name. Ira is saying, so I should reach out to the city attorney. That would be perhaps my best contact regarding this.
I don't know if it's your best, but it's one, but you should
and
also.
The housing department. Yeah.
Yeah.
Okay. This woman at the housing department though said that if it's in my lease, this is the quantity.
So submit a formal complaint on the housing department's website. They have a form that you can fill out for violations of the Rent Stabilization Ordinance.
Rent Stabilization Ordinance. Go ahead.
So that is what I would recommend rather than trying to call them.
Violation of the Rent Stabilization Ordinance. Okay. And so just to get an eye, and I'll let you go, should I cite this then? Would this be a wise thing to put in there? Penal Code 396, as well as a violation of the Rent Stabilization Ordinance? Is that, I'm trying to get a sense of my wording to them when I put in the complaint.
Sure, but they'll probably, it's more important to give them the facts rather than, because it's their job to know the law. But your facts are personal to your situation. So when you're conveying them, you don't necessarily need to have this
I say
citation.
Right.
So
I'm not the lawyer. Okay.
Well, but the city might not have in mind, the housing department might not have in mind this anti-gouging law, because it's a law that applies not just to housing, but all kinds of things. So it's a good idea to say 396.
Okay, that sounds good. Sure, Ira. Yeah, I was just going to say it doesn't hurt. It won't hurt me to just make mention of these things. Okay.
No. Yeah.
Okay. Well, and last thing, very quickly, I have been dealing with harassment. My place has been someone has the keys to my apartment on this property. And I know because not only do I have missing things, but they have made it apparent to me by doing stupid things like taking my tennis shoes, stealing my tennis shoes, and then them showing up again like 2-3 weeks later when I walk into my bedroom and they're sitting right there, if you know what I mean. I'm sure other tenants, this is a common kind of practice, taking my shaving blade and putting it in my kitchen drawer, letting me know that someone is in this apartment when they come in when they want. Because we had a little dispute sometime early on when I moved in. They were coming in without my authorization. I understand there's a 24-hour, and I was letting them know about that in a very diplomatic, nice way. But I think somebody took umbrage to it, and this place is a little bit, I've had mail theft here. There's some crime going on around here. For harassment, is there any organization I could reach out to, because that's also going on?
Again, State House Los Angeles will write a letter on your behalf, but if somebody is regularly entering your home and interfering with your possessions, it might be something that you would want the police to be involved with.
Yes. I've reported it. They've done little to nothing.
Right. Yeah. So State House LA can, if you believe it is your landlord who's doing this, if it's another tenant, it's a little bit more complicated.
Right. I had my locks changed. About 3 months ago, and it's still going on, which to me clearly, as I emailed my landlord, I am the only besides myself who has the keys with the new locks. You are supposed to be the only other one. So that kind of, doesn't that put them in a position that has the keys to complete the sentence? They're the only other ones that have the keys with new locks, right? So it must be them or someone that they know or associated that they are, because they want me out. I think they rented this place out to me at less money than they were hoping to get because it was in the middle of the pandemic and they had open units. And I think that they feel like maybe they can get more money.
So to answer your question, State House LA can help you with harassment.
Okay, State House LA, is that?
Yes, and if you're in Koreatown, it's statehousedla.org. I would also recommend reaching out to the Los Angeles Tenants Union because it is fairly robust in Koreatown, and other tenants might have good suggestions for dealing with this situation and for supporting you.
And I'm sorry, could you repeat that, Sarah, that last place you were talking about?
Los Angeles Tenants Union, the Los Angeles Tenants Union.
Okay, Los Angeles Tenants Unions. Okay, very good.
All right.
Los Angeles Tenants. Thank you very much for your help. I appreciate you and Ira taking the time.
Nicholas K., what is your question?
Hi, thank you. I'm speaking on behalf of my neighbor. She received a 3-day notice to quit today. It came in the form of a lawyer letter. My first question is does that actually count as a proper 3-day notice?
Yes, there are landlord's attorneys who will send the letter on behalf of their clients. It has to include certain information, but it's often a good way. They often do make sure that they comply and that they give the notice correctly.
Okay, thank you. And so what they're basing this 3-day notice around is my neighbor having a guest, and they're thinking that this is an unlawful resident, and they cite seeing continuous existence of this guest the last 30-day period. What does my neighbor do? Like, how does she move forward with trying to fight this 3-day notice?
She can provide the landlord with notice or with, I would say, like written communication, like a text, an email, a letter saying that this person is not living with them, that this person lives at a different address, that they receive mail at that address, and that if they are frequently appearing on the property, it is because they are, just a visitor. Again, if this is in the city of Los Angeles,
this is Koreatown.
It's worth reminding the landlord that evictions for unauthorized occupants are currently prohibited under the Los Angeles the Los Angeles COVID protection laws. So she can reach out in that regard. And if the landlord does file a does file an eviction, an unlawful detainer, an eviction against your neighbor, then she can. I would recommend going to Stay Housed LA and being in touch with an attorney, because we do see that this is quite common. Landlords will say that somebody who is a friend or another neighbor or just doesn't live there is actually an unauthorized person living there, and they do it pretty frequently. But getting somebody to help your neighbor will be a good way to make sure she's not evicted for this situation.
Okay, thank you.
All right, Rose.
Hello.
Hi.
Hi. Give me a second. Need to provide him the address to where I'm moving
You don't have to do
within
any of
48
that.
hours.
You don't have to do any of that. So you don't. He's basically making baseless threats, and landlords do this a lot. You can just ignore their calls, ignore their texts, check it once a week, and there's no authority that says that you have to tell them when you're moving out by, or if you're moving out, or well, you do have to tell them if you are moving out. You're supposed to give notice, of course, but where you're moving, it certainly is not their business. So you do not need to give him this information, and there's certainly no 48-hour deadline for it.
Okay, so yeah, that's what I wanted to know. Thank you, because at the 60 days, I haven't found nothing that I can afford, and I have 3 kids. They cry at night, saying that they're scared because they're constantly going, and not even, they don't, like I said, yesterday they went trying to go into the apartment, and I'm not even home, and I was not even notified that they were gonna show up.
So again, they are breaking the law. They are harassing you. You don't need to respond to their texts and calls. You can block their numbers. You can block their emails. And if they're giving you notifications that are formal legal notifications, those have to be on paper, and they have to be just, if they need to communicate with you, you can tell them that it needs to be in writing. It needs to be printed out, put in your mailbox. And that everything has to have that 24 hours notice, because that's what you're entitled to. That's what you get as protections.
Okay, thank you.
All right, M. Rudolph.
Can I say something just to help her out?
Sure.
I write everything down and make sure you say those texts, because if it comes down to it, you have all that as harassment. That's pretty bad at what that guy's doing. Another thing too, keep on coming to the seminars, because I guarantee you come a week or 2 or more, come Tuesday, come every day. And the longer you come to it, you're going to get more confident and you can fight back, because all the stuff he's doing is pretty bad. And I hate to hear people speak stuff.
That's what I told them. I go, I'm supposed to be your family through my husband's side. I go, I've been here 15 years, and his dad had an accident.
But that
like
doesn't
7
matter
years
when
ago.
it comes to that doesn't matter when it comes to money. They don't care. So just don't take that approach.
Yeah.
Do
But
it the legal way.
I was in charge of the repairs and everything for the apartments for the past 7 years. I've dealt with all the apartments myself. And now all of a sudden he comes in.
Yeah, don't worry about all that. Don't leave all that out. When you just need to fight everything legally way. Like she's telling you, fight everything. Educate yourself on YouTube. Look up the codes, whatever they say, and educate yourself, and then fight back the right way. And then remember, don't respond back, because they can use everything against you. That's all I could tell you. But keep on coming to those webinars, because you're gonna learn, and that's the best way to fight back. Believe me, we've all been there, and the more we come to these meetings, the more we learn.
Yeah, I was just afraid, because he was saying you have 48 hours to respond to me with when are you moving out and where are you moving to. Like, I was
He can't do that. Stop saying that.
Step out of work.
He can't kick you out. Just think about it. First thing, he can't kick you out. So all depends where you live. Look up, just research yourself, and where you live, you can't do that. So just keep that in mind, and keep on coming to these webinars, and then think that. Okay, this is the first step. Listening.
Okay,
The 60-day notice says that he can kick us out prior to the 60 days.
that's not true.
Yeah, she knows. Listen to her. It's all BS. They're just trying to scare you. Don't listen to it.
I'm gonna get this back towards the Q&A just because we only have 20 minutes
Thank
left.
you.
I know everyone has a lot of questions, but your landlord cannot kick you out. The landlord can never just change your locks. They can never take your stuff out and throw it in the street. All of that is illegal. They don't have that right. That is against the law. You have rights as a tenant, and if your landlord is calling you constantly or texting you or anything, and you start ignoring those calls and texts, it's not that some offer is only going to be on the table for only 48 hours. That's just not really how it works. Everything is still on the table. Saying that there's a 24-hour or 48-hour time limit is always just not true. So that's just something to keep in mind when you're dealing with your landlord. But I'm going to move on to M. Rudolph. So M. Rudolph, I know you've had your hand up for a little bit.
Can you hear me?
Yes.
Okay. So I think mine is very similar to Matthew's a couple of questions ago. At the end of June, I was given a 90-day notice that my rent was to increase 32%. And I tried to do as much research as I could. I talked to the Housing Rights Center. They began to tell me like, no, that, it's against it's anti-gouging laws, California Penal Code 396. I shared this with my property management company multiple times, just like, please, you have to change it. It's not correct. I understand 10% is the legal limit. I'll pay that. I did end up paying that in October, and I still received a 3-day notice to pay rent or quit. So it's where do I stand at this point? Should I be scared that they're going to lock me out or evict me? And
so you don't need to be scared.
That's where do I go from here?
Because like you said, that this rent increase was illegal. A 32% rent increase is ridiculous and frankly unheard of in my experience. I'm sure it's not unheard of. But it's frankly ridiculous, and in many cases it violates the state law, it violates municipal laws, particularly if you're in the city of Los Angeles. So getting the 3-day notice is very scary, but you don't necessarily have to be scared. It is possible that your landlord will file an eviction case against you. And if that happens, you'll receive documents called like a summons and complaint and a notice of a filing against you. And all of that will come from the court. And those documents might look scary on their face, but they're really just very simple court documents. And you can go to Stay Housed LA and send them those documents and tell them that you had this ludicrous rent increase, and that and they will be able to assist you. They can, if they tell the judge, the landlord increased the rent 32%, that's where this extra rent payment is coming from. It is likely that the case would get dismissed fairly quickly, but of course it is scary. There's like a concern that they would lock you out, and if they do lock you out, Sarah posted in the chat that there's a phone number you can call that will get you immediate assistance, and there's people who are there to protect you or to help protect you and help you stand up for your rights. So all of that is to say that like you do not need to be scared, but you just need to be aware. And once I would reach out to Stay Housed LA now, because you received this 3-day notice to quit, and it's possible that they could file an eviction against you, and you want to be out in front of that just to make sure you file your responses in time and are able to protect your rights.
Okay, thank you so much.
All right, there's a phone number that I see a hand raised. So it's the phone number ending in 8753.
Yeah, can you hear?
I can hear you. It's a little bit patchy. Now we're not hearing you at all. If let me see if I can.
Okay, I just unmuted again. Is that better?
That's good.
Okay, I received, and I'm going to read it to you. Notice of termination of tenancy due to withdrawal of property from the rental market. Properties exempt from AB 1482, but subject to CTRA/AB 3088. It's a 60-day. And here's the weird thing. The landlord, I live on her property, I rent a room. She put, it's signed by her realtor, and her realtor is claiming to be the owner now.
So there's a lot going on with that. So what your landlord is trying to do is called an Ellis Act eviction, which is when
What can repeat that, darling? You talk a little fast for me.
The Ellis Act. And the Ellis Act is basically something that gives landlords the right to evict their tenants when they are going to remove the rental property from the rental market. So basically turn it into a property that's owned by the person who lives in it. They're not going to rent it anymore. Maybe it'll be, if it's a big building, it could be turned into condominiums. And generally, those evictions are legal, and they're permitted under the COVID tenant, or no, I don't believe they're permitted under the COVID tenant protection laws. So it is possible that your landlord cannot evict you because of those COVID protection laws, but in the future they might be able to evict you. Can you tell me, how many units are on the property?
No, it's a condo. I'm renting one room in a condo.
One room in a condo. Okay.
Mm-hmm. And the landlord is claiming, I believe, falsely, because she wants to escape responsibility for harassment that I've been reporting recently, and reduction of services, like tons of things. Plumbing, air temperature, there's just a lot of things wrong. And when I complained about it, that's when I got the notice. So I believe it's retaliatory. And then suddenly she's claiming that there's a realtor who owns the property and not her. Is there a way I can find out if that's true? Because I'm pretty sure it's false.
So you can do a title search to find out who is
in the premises, then and that's all it is. I mean, there's part like single rooms, and then there's some like that's efficiencies. So then does that still qualify them for the laws under single family?
So if it's being treated like a boarding house, you mean?
Yeah, it's more like multi-unit building.
So if it is registered as a single family home, but it is essentially functioning as a multifamily building, then generally speaking, no, the landlord cannot claim it's a single family home, even if it is registered in that way, because maybe at some point in the past it was a single family home, but it is no longer the case.
So then does that mean there are some things that they didn't pay to make it a multi-unit building?
It's likely that they didn't properly register the building with the city or the county, depending on where you are. But if it is, especially if these are full like efficiency apartments within a building,
yeah,
that does sound like it is not properly registered.
Oh, so like, how do tenants get relocation expenses through their landlord?
So that's a good question. In a lot of cases, they write a letter explaining their rights, or having somebody else explain their rights, and they come to an agreement saying, I will move out by this deadline if you pay me this amount that I'm guaranteed under the law. And that is how they get these relocation funds. In other cases, the the landlord brings an eviction, and the tenant, they get in touch with an attorney, and the attorney says, if you're willing to move, you could probably get you're entitled to money under the law, and we can ask for it. And then they strike up, they come to that deal with the landlord and with the landlord's attorney. So that's usually how that goes.
If no like unlawful detainer has been served, then, and there's been a lot of harassment, but like how do you go about asking for relocation expenses?
To your landlord, I would recommend asking in writing. You can send an email, you can send a letter, you can work with an organization to get a letter to send to your landlord. But so you can't necessarily, there's no specific way of doing it necessarily, and it's going to depend if your landlord is a person who lives in the property with you, or if they're a person, or if they're a giant corporation, then they then it's going to be different, just depending on how you have to deal with them. But it's starting that conversation.
I have another question. For housing is key, if you have some type of back payments before COVID, but then it's charged like a certain amount
we're
per
losing
month
you.
Am I?
So I can't hear you, at least.
Oh, okay. So like for housing is key, can we apply for back rent that's being charged on a monthly basis during the COVID months?
Yes.
Oh, we can.
Yes. So any rent that was charged throughout COVID, that you weren't able to pay because you lost income, or you had extra expenses, or you got COVID and you had to pay for medical care. Yes. And I'm going to end this call because we're getting close to 7, but I see one question in the chat that I wanted to address. And it says, as of November 1st, landlords have the right to file small claims. That is true, yes. As far as we know, the landlords can begin requesting the back rent beginning November 1st. I'm not sure if that's going to change because of all of the rent relief. I don't think a small claims court would order a tenant to pay the rent while they're waiting on the rent relief from the state, but we'll see.
I think that to file for a landlord to sue in the small claims court, they got to give the notice that they've applied for rent relief. And also, there's an argument. It might be true that if you're in the city of LA or some other place that says that the back rent isn't due for a year after the emergency or something like that, then it might be that the landlord will lose the case because the rent isn't due. It's unclear if if the judge will accept that argument, but they might.
It's unclear, so we don't know. We don't quite know yet. But yes, in general, it is possible that your landlord might file a small claims case against you. We don't know what's going to happen once these small claims cases open up and how they're going to be handled. Keep coming to these events to learn more as we get a better idea of how that's going. All right. So thank you all for coming. If you didn't get your question answered tonight, I encourage you to keep coming to these events. And they're every Thursday. There's also trainings and other clinics. Yeah, if you have questions, I really encourage you to keep attending, keep learning more.
Awesome. Thank you, Sarah. With that being said, I think we can go ahead and start wrapping up the meeting. So everyone has the clinic